So, what are 5 things you should consider if you're giving assets to someone who struggles with addiction? Hi, I'm Claire Langton-Yanowitz at the Yanowitz Law Firm, where we've been helping families in all sorts of different situations for the last 29 years with their wills, trusts, and probate. Okay, let's get started. So, the first thing that I think you need to consider when you have this scenario of a child who struggles with chemical dependency or addiction is how much are you going to give this person? And I have seen families handle these things so differently. On one side, sometimes people will just treat the child equally. They say, well, I don't want to provide any favoritism. So we're just going to treat everyone equal because that's what's going to keep the peace, keep the harmony. And that's what's fair at the time of death. Another version of this I see is that sometimes people want to give the person with chemical dependency maybe more. Maybe they say this person, doesn't have a lot of savings. They have a lot of needs. Rehab can be very expensive. And so I want to give this person a bigger share than their siblings. Sometimes it's a bigger share. Sometimes it's, I want to give them an equal share, but at a minimum, I want to give them $1 million, for example. So, if their share is less than $1 million, okay, so like if mom and dad have 2 kids and at the time of death, they have 3 million. Maybe this kid gets 1.5 million in that scenario. But if, at the end of death, at the end of their lives, there's this big spend down with medical bills. And, at the time of death, they have 1.5 million. What will happen between the 2 kids is the kid with chemical dependency is going to get $1 million because we set a floor on that. They're going to get at least $1 million. And the other child is going to get 500,000. So that's one way to write it. Okay. I've seen people go to the other end of the spectrum and say, well, I want to give this child less than their siblings. And different rationale that I see used with that is maybe their health is poor. And so maybe, you don't foresee that maybe this person might live a long time. Maybe their ties to the family have been weakened over the years. And so people want to give less. Sometimes I think people want to give less because maybe throughout the years, mom and dad have provided this child more assistance than the rest of the other children. And so they view it as, they already got some of their inheritance up front. And so they want to give this child less at death. So that's what I see as the arguments of giving this child less. Now, I think most of the time when we have someone with addiction issues, oftentimes parents want that child to inherit in a trust so that the child doesn't just get free range to the money. There can be this concern that if this person with chemical dependency issues gets control of all the money right away, that, they may use the money to hurt themselves. They may blow it quickly. And, that really the goal is to create this nest egg that the child will have so that, they're not going to be on the streets in the future. They're going to be taken care of, at least with basic support. That's what I oftentimes see the goals of parents. Now, on the reverse side, if you don't want them to inherit in trust, they could inherit outright, where they get the money in their direct name and they can spend it however they want. And so sometimes people will say, my kid's 50, they haven't made maybe they have this addiction issue and they've struggled, but they're an adult. I don't want to have somebody else controlling their money when they're at this age in life. So that's what I see as the argument of let's just give it to them outright. Now, for the people that say, no, I want it to go in trust where the child doesn't have direct access, somebody else is in charge of the money and distributing the money for their benefit, those people have a couple of other decisions to make. So we can write different types of trusts. We can write a trust that is very, very narrow, where we say, they can't get access to these funds except for to pay for rehab, or once they demonstrate that they have not been, that they have not been, using drugs for a period of time or drinking alcohol, and the trustee has the ability to test for these things. So maybe they have to be sober for a year or 2 years before they can get at the funds in the trust for other things other than rehab. So that's kind of like the most kind of more restrictive type of trust. On the less restrictive type of trust, sometimes I'll have parents say, well, I don't want my kid to end up homeless. I don't care if they're still using, they're not sober. I hope that they do sober up, but if they don't, I want them to have a place to live. So I want this trust to cover rehab, but I also want it to cover basic living expenses. So this isn't opulent living expenses, but we want the basic necessities taken care of for this child. And oftentimes what a trustee will do is, if at all possible, they'll pay expenses directly for the child. So the child won't get the money directly. The trustee will pay the kid's rent. They'll pay for the medical insurance. They won't be distributing that money directly for the child and then have the child take care of their own bills. So that's something to know. I would say on the most liberal side of kind of how should distributions be made, sometimes people will say, well, I don't want just the basic necessities, but I want other things on top of that. So I've had people before where they'll say, well, for example, my child smokes cigarettes, and, while, those can be harmful to your health, that really helps with their anxiety. And I want them to be able to use trust funds to do that. So sometimes there are some other kind of random things that may not be considered basic necessities per se, but that we want to consider and write into the trust to say that they can get more on top of the basic necessities. So second thing to think about here is, how should someone inherit? Should they inherit in trust or outright? And if it's in trust, how loosey-goose terms should that trust be? Should it be very, very tight, where they can only get at the assets if they're in rehab or not using, or should it be more loose in distributing? Okay. Now, the third thing that you should think about if you're in this situation is, who should be the beneficiaries of that child's trust if they're getting a trust. Okay. And so the options are, the child can be the only beneficiary. Okay. A second option would be that the child and the child's descendants are beneficiaries of that trust. Okay. And with that, that can be helpful. Maybe your child has, you have some grandchildren with them, and, your child has had struggled throughout their life. And so, those children haven't been supported, the grandchildren, maybe in the financial way that you would like them to be supported. Sometimes we will create that grandchildren as part of the kid's trust, so they're all beneficiaries of the trust. Sometimes those grandchildren have a separate pot of money. So we say, $1 million is for my son with chemical dependency, but then I also want to break off and say, $300,000 goes to this trust for the grandkids. So they aren't like, they aren't at odds with each other, that dad ate up all my money, or, that they're not sharing one pot of money. Sometimes people won't want to include the grandchildren. Maybe people don't have a tight relationship with them. Maybe your child has struggled a lot and has had, maybe lots of kids, and maybe we don't know where all those kids are even. And so we want to knock out those grandkids because we don't really have relationships with them. So these things can get complicated, I would say. Now, a fourth thing that you want to think about is who would be a good trustee, okay? And who would be a good trustee oftentimes is someone who's an independent third-party person or bank, because I think that if you put a close family member in charge of these types of trusts, it sets it up for a complicated relationship between your child and the trustee. If like a sister or brother is in control of your son's purse strings, no, you can't have that. That can be a problem. And I think that two things can happen. First, the relationship can be weakened, can be destroyed. That's the first problem. And then the second problem is the sibling might get so worn down that they don't respect the terms of the trust, that they just start shelling out the money to your son with chemical dependency because they're just worn down and they're sick of saying no, and so they just do it. So I think oftentimes in these situations, it's better to have an independent person, bank, party doing it, because that's getting paid to do it as a job, because listing a family member as the trustee can be an issue. Now, I think that, what you can do is sometimes people will want like a trust advisor where, the trustee can talk to the trust advisor on how the child is doing. That there can be involvement with maybe someone from the family that knows the person better, but not to have that family member be directly in control of the purse strings. And then the final thing I think that is important to consider is that it's good to revisit these plans every couple of years. Especially, it's good to do that with all types of estate planning, but especially this type of estate planning. I find that people with chemical dependency, you always hope that it gets better, and sometimes it gets better. Sometimes it gets worse. Things change, things evolve as time goes on. And so it's good to revisit these every couple of years and make sure the plan that you have in place makes sense. It's not too restrictive. It's not overly loose, that it makes sense for your family. So thank you so much for listening today. If you'd like to learn more about estate planning, hit the subscribe button to our channel so you'll be notified every time we release a new video on estate planning. Thanks so much.